Good morning, everybody. My name is Stephen Evans. I'm a partner in the Healthcare Advisory team. I'm based in Yorkshire, in Harrogate, but cover trusts all over the country. I have a brief background. I've been with Hempsons now for almost 28 years. And when we get to the end of the slide, you'll see I'm looking a lot older than my promotional photo. But I have spent most of that time in advising around healthcare issues in general, specifically in relation to mental capacity and mental health. I shall now just let my colleague Clemmy introduce herself.
Thanks, Stephen. Yes, hi everyone, I'm Clemmy Robertshaw and have a similar function to Stephen, but I'm based in the London office and similarly do a mixture of work for care providers, funders, etc., where Mental Health Act and the Mental Capacity Act are involved throughout the country, but more, I guess, in the south because I'm based here. And I haven't yet spent 28 years at Hempsons, but the interesting part of my history for these purposes is that I used to represent patients who are detained under the Mental Health Act. So I've kind of seen it from both angles. And we also both do work involving inquests and, situations like that where something perhaps hasn't gone to plan or people think it might not have gone to plan, and kind of analysing it after the event. But the more optimistic work is when we're trying to help people get it right in the first place in complex care planning, etc., as Stephen set out.
This webinar is meant to be a high-level consideration of strategic issues. And if you've got concerns, please do, as I say, raise them in the chat. We'll try and address things. The other webinar we plan to do on this topic is practical guidance for clinicians actually working in the acute setting and being faced with patients detained under the Mental Health Act or who could be detained. So please do have a think in your organisations about who should hear that. And then when the invitations for that come out, you can help us get them to the right people. So this is what we are going to cover. When the use of the Mental Health Act can arise, and that is going to be Clemmy. And then I will look at how the Mental Health Act works and what it authorises. And then we'll look at working together, acute and mental health trusts working together, the role of security teams, where the ICB can end up involved and so forth. CQC and registration in relation to mental health care and treatment for acute trusts. Service level agreements and employment issues that might potentially arise. And then we hopefully will have some time for questions and discussion at the end.
So we're obviously talking about the use of the Mental Health Act in the acute setting, where the Mental Health Act is really intended to primarily address psychiatric care in what is a sort of narrower sense. And obviously care has, since the current version of the Act was originally conceived in the 80s, has moved on quite a lot, such that care is a lot more complex and public services have changed in structure, shall we say. So there is an increasing number of incidents and times where there's more of an overlap, where you've got patients who have more than one type of need that needs to be addressed at the same time, or different services that are involved. And I think anecdotally we would say an increasing number of these really complex situations, like dealing with eating disorders, where there is simultaneously significant physical health and mental health issues that need to be addressed together. So this is a list of some examples of times where we are often advising on the use of Mental Health Act powers in an acute hospital setting. But one thing that we need to probably make very clear about this is that the Mental Health Act and the Mental Capacity Act, while they have similar words in them, are very different. They may both apply, but we don't have really time in this webinar to cover both in detail. So this is kind of putting the Mental Capacity Act to one side for the moment, and looking specifically at the Mental Health Act, which fundamentally exists for, there'll be more on this later, but it's more about holding someone to keep them safe and compelling treatment as required for mental disorder. So it's looking at the side of detention or restraining someone, for example, in the context of other care. So these are situations where that might be a question that's coming into play, and it might be that you need to think about the use of the Mental Health Act, but the Mental Health Act might not be the answer to the problem you're dealing with. So the types of situations we see quite a lot, for example, in emergency departments. I think nowadays every ED is seeing an awful lot of psychiatric related cases, and for instance, quite common problems with police bringing people in with Section 136 powers, which belong to the police under the Mental Health Act. And then the challenges of trying to complete assessments, identify next stages of care and move someone on within the 24 hours that Section 136 allows. I've mentioned eating disorders and the complications around feeding and physical health care for patients with eating disorders. And obviously that's particularly complex where you might have a patient who is under 18, a child or a young person, and we're all very conscious of how those issues are exacerbated by the problems with CAMHS beds and not having always these specialised places that would be the preferred environment of care for that sort of patient. Really any medical discipline and general medicine can deal with patients who have significant mental health problems and therefore might be thinking about the use of the Mental Health Act, including things like people who have physical health problems which have arisen secondary to their mental health due to, for example, self-neglect, maybe similar issues with feeding that are more to do with the patient neglecting themselves and not feeding themselves properly rather than a specific eating disorder. Surgical teams might be involved with the Mental Health Act, for instance, where you have patients who need treatment for self-inflicted wounds that might include plastic surgery, for example. And probably the most clear-cut case where there is legal complication that hopefully is seen on the horizon in good time is where you have obstetric patients who've got significant mental health problems. And particularly if you've got someone who is sectioned and pregnant, you know that there is going to be a question and a complex care planning that is needed at some point, and so that will need to be dealt with. But in any of these situations, it might be that someone is presenting to acute services with a mental health problem and a physical health problem, or just a mental health problem, or what have you. But you also might be dealing with, for example, patients who are detained under the Mental Health Act in a psychiatric unit and then are transferred while still under section to an acute hospital for physical health care. So it might be that you're thinking about the application of the Mental Health Act, or it might be that the Mental Health Act is already there and you need to know how to operate within that legal framework. And in dealing with any of those issues in this sort of context, you obviously have to think about the ramifications, which we'll talk more about in terms of whether the staff are capable of dealing with these issues, whether they have capacity, do you need additional staff? There'll often be arrangements for having bank staff to have an RMN, for example, with a patient, but you don't always have notice to get that planned. Do you have issues with patients who can easily leave an emergency department when they are supposed to be staying within the emergency department, etc. So there can be a lot of complex issues around it. Hopefully the point of this seminar is to highlight questions that you might need to think about in advance, because they're very difficult for clinicians to deal with just ad hoc when the issues arise. We refer to liaison services there because from the experiences we have, we can see that liaison services vary wildly in terms of provision across the country, and different SLAs are set up everywhere. So it might be that there is a mental health liaison team in an emergency department that only does assessment of mental disorder, or is only involved at that stage, and isn't then available to assist and advise acute clinicians working in, for example, obstetric care. And there isn't an obvious person for those clinicians to go to ask for help the way they might for a liaison service that has a wider coverage. And one of the things we probably flag here is about the liaison service roles varying, meaning you can't just rely on what has happened before to happen again. And that, I would say, is a general issue that we see quite a lot, where something has happened in the past, we just assume it'll be the same, or that it should be the same, or that whatever happened was right, because some clinicians have some experience with this rather than anyone really knowing what the rules are. But where there is provision of a liaison team, that should be very helpful to acute staff. The other issue that arises in that situation that we see quite a lot is, particularly in inquests, sadly, and where people have left an emergency department, is a perception that if someone comes in with a mental health disorder and they're referred to the mental health team, that patient becomes the mental health team's patient and they are responsible for all their management. But actually, if the patient is in the emergency department, they are the patient of the acute hospital, and that responsibility doesn't diminish just because there is consultation with what is effectively an in-reach advisory service. So the other kind of particular thing to think about is where there are red flags that make you think about the Mental Health Act, but it's actually maybe not the most appropriate route. So, for example, where you might have patients with dementia, then the fact that they happen to have a diagnosis doesn't necessarily mean that the Mental Health Act is appropriate to try to implement care around it. It might be, but just because there's a diagnosis, and the same would apply because someone comes in who is known to have schizophrenia, doesn't necessarily mean that that is the problem or that necessitates any use of mental health powers. So it still needs to be considered, and obviously that can be for any kind of health issue. It can be in the context of dental care, and sometimes you need to think carefully or get advice, making sure you know how to escalate and who in your organisation, including legal team, to get help from. If you've got a situation where, because of someone's mental disorder, you might be thinking about restraint or a more restrictive approach to their care, or fewer options being offered to them, but actually the care being provided is purely a physical healthcare issue.
Thank you, Clemmy. Right. Okay. So taking an overview of how the MHA works and what it can authorise, I'll just mention here that in terms of these overview slides that Clemmy's just talked about and this one I'm talking about, we may come back to some nuance and the subtleties of it all and the practicalities of some of it when we're talking about service level agreements and the sort of things you need to think about that ought to be covered. So the Mental Health Act, this is trying to, in the acute setting, identify when are you thinking about the Mental Health Act potentially. So what it can authorise is detention stroke deprivation of liberty. For this purpose, I'm going to treat them as being the same thing. It will authorise that person being kept in the hospital and not being allowed to leave without permission. It will then also authorise treatment for mental disorder. I shall come back to that in a moment. And it can also authorise a transfer between one hospital and another. So coming back to treatment for mental disorder, the important thing to realise about that is that treatment is very wide, but you can include a lot of stuff in it. It will include feeding, it could include giving antibiotics, it could include potentially delivering babies or surgery. But it is not a blank check. It must fundamentally be linked to the intention to alleviate or prevent a deterioration in the mental disorder. And if there's no link with a mental disorder or impacting on the mental disorder, then you can't use the Mental Health Act. It's also important to separate out the idea that you're authorising detention from the idea of treatment. So do think about them separately. What is it, we need to do? How else might things be authorised, which is where you would consider the Mental Capacity Act, or if you're dealing with children, you might be able to rely upon the consent of somebody with parental responsibility to authorise detention if they're under 16, but those with parental responsibility can't authorise detention if they're age 16 and 17. Or you're relying upon that to authorise the treatment. And there are subtleties in that that mean you may not need to use the Mental Health Act, or that the Mental Health Act can cut through other difficulties. So in particular, the Mental Health Act covers people who both have and do not have capacity. So it doesn't matter, in effect, whether the person has capacity or not. You still need to assess it, and you still need to decide which you're dealing with. But the Mental Health Act can be particularly useful for people who have capacity but are declining intervention or treatment of some kind. The other thing about the Mental Health Act is that it has no age limit. So children can be detained under the Mental Health Act, but as I've already mentioned, you can often achieve the same effect with the consent of those who have parental responsibility. So it may not be necessary to use the Mental Health Act, but it is there if there are issues about whether people have parental responsibility or there's disagreement between people with parental responsibility as to what should be done. It may be appropriate. What you also absolutely need to realise about the Mental Health Act is it is very process driven. And acute trusts, not being as familiar with the Mental Health Act as mental health trusts, potentially don't appreciate just how important this is. But there are various points at which the documentation must be in the right form, I mean literally on the right form, and correctly completed. Otherwise, the detention would be unlawful. There are time limits, and there are review processes. So I've had situations, for example, we may come on to talking about the doctor's power to exercise short-term detention, section 5.2 of the Mental Health Act. That lasts for 72 hours and cannot be renewed. So you can't have consecutive 5.2s, because the purpose of that detention is to have a full assessment for further detention under the Mental Health Act. A 5.2 also doesn't allow treatment to be given. So there are subtleties in the Mental Health Act that have to be appreciated if it's to be applied correctly. Review processes include the option for the person who is the nearest relative to discharge the patient, although that can be blocked. Asking for managers' hearings, which acute trusts will not be familiar with, or asking for tribunals hearings, which again acute trusts will not be familiar with. And this will again come back to SLAs and agreements with local mental health trust about who's going to run these processes. The final thing that is important in the acute context to appreciate is that treatment under the Mental Health Act is authorised by an approved clinician. The approved clinician is somebody who has been approved under the Act specifically, and will normally be a psychiatrist. It'll be somebody with an interest and knowledge of and experience in the diagnosis and treatment of mental disorder. The vast majority of acute trusts will not have any approved clinicians. So that means if you are treating somebody under the Mental Health Act, the actual legal authorization for that treatment will come from a clinician, an approved clinician, who is probably not employed by the acute trust. So you have to be able to get one in the first place. And then the acute trust clinicians have to realise that there must be close liaison in establishing the care plans and having the care plans approved, because the legality of the implementation of those care plans, where treatment is under the Mental Health Act, comes from the fact that either the approved clinician is giving the treatment, or it is being given, more likely, it is being given under the authority of the approved clinician. So you're not just free to go and change your care plans and do something completely different without the approved clinician being aware of it. Now, in terms of terminology, every detained patient will have a responsible clinician. And the responsible clinician, or must have a responsible clinician, the responsible clinician is the approved clinician in overall charge of the care of the patient. So often, that's why I've put that slash there. The person you're dealing with will be an approved clinician who is the responsible clinician, and the responsible clinician is often the phrase that you will come across.
So expanding on some of those points, really. So Stephen mentioned approved clinicians are approved under the Act. That's under Section 12 of the Act. There is a specific process that a clinician has to go through if they want to become an approved clinician under the Mental Health Act, in order to have these additional roles. And these are other types of staff where there's likely to be a lacuna for the acute trust, but it's something that mental health trusts do all the time. So, for instance, a mental health trust will have a Mental Health Act office and have staff whose job it is to deal with the forms that the Mental Health Act generates, which were previously been mentioned. And in terms of the Mental Health Act being process driven, it's extremely important to have someone who knows what they are doing, checking the paperwork to make sure it's been done right, because if it hasn't been done right, the section isn't lawful, potentially, and therefore the period of detention isn't going to be lawful. So it's very important to have that sort of structure in place. And it's essentially, these are points why acute trusts don't want to just start sectioning people. They need to have all of these safeguards in place for patients as well as for themselves. Managers' hearings in tribunals, which Stephen mentioned, the acute trusts are not going to be very familiar with. They're not necessarily going to know about the time constraints on that. They're not necessarily going to have all the processes in place to arrange for hearings or to have associate hospital managers ready to go to hear a case. And they are specific people who are separate from the trust, but engaged by the trust to hold hearings to review periods of detention. So they're a safeguard to check whether detention has been used correctly by the trust and its clinicians. So obviously that's an important thing, but also has to be set up in exactly the right way. They have to act on the delegated authority of the trust. So all those systems need to be in place, and it's not possible for someone who works for the trust to just say, I can sign off this form on behalf of the trust. But that's the kind of issue where it's not necessarily that obvious at the point that you're looking at the form that you're not authorised to sign it on behalf of the trust. So these are issues where it needs to be planned ahead. You need to know what the systems are. The other thing I'd flag in relation to approved clinicians in particular is that obviously that's a subtype of usually doctors, and the student says usually psychiatrists. But there are also roles defined in the Mental Health Act which acute trust will have, like doctors, which is a person used in the Mental Health Act as well. And he mentioned Section 5.2 powers. Any doctor can use Section 5.2 if the criteria for its use are met. But again, if you don't then have someone who can check the paperwork's been done right to know whether that's been lawful, it's maybe not a good idea to just go around and use a 5.2. And then there's a similar power under Section 5.4, which allows nurses to hold patients for an even shorter period of time to get a doctor to come. And then the point of the Section 5.2 is to then get a Mental Health Act assessment completed for a formal, proper, longer term section. But the nursing power is restricted to RMNs. So it's not just any nurse. And again, that sort of thing isn't going to be obvious at the time that you're dealing with it, or if you've got colleagues who have some familiarity with the Mental Health Act but don't really know the rules. Acute trusts may not have staff who are particularly well trained in restraint, or enough of them if you have issues that are sort of cropping up in an unplanned way in unplanned wards. And there might need to be sharing. And we often see agreements between mental health trusts and acute trusts to provide linked up services so that the mental health trust staff who have the relevant skills in terms of something like restraint, but more particularly things like the Mental Health Act office, checking forms, arranging hearings. If that work can be shared, then you hopefully between you can have all the right expertise to make sure that the care is being done correctly and lawfully. Acute trusts also need to work with people like security teams who may be externally provided and contracted to them, but might end up being very important in the situation, like if someone needs to be restrained, if someone needs to be prevented physically from leaving. It may just be that the presence of the security team is very helpful, or it may be the opposite. But in my experience, security teams are often fantastic and understand there are limits on what they can do, and know where to get the answers, but they won't always. And there obviously needs to be good communication between different professionals working together, even if you're parts of different organisations, to make sure that you have the same understanding and the right understanding. Particularly, for example, if you're planning care for someone, and you anticipate that they might need restraint or you might need a security presence, and you can think about how that can work in practice. And I'm conscious in talking about this that not every unit where you're dealing with patients will there be security. I think they're increasingly common in an emergency department, but not necessarily in lots of other settings where it may be that actually these issues are coming up in a more unplanned way with staff who are even less experienced at managing that sort of situation. And obviously the relationship between trusts and funders is really important to make sure that you have provision to be flexible if needed around additional needs. For example, more staffing, whether that's on a flexible basis or there is an increasing presence of psychiatric presentations which take up more staff time and therefore there's an overall need for more staff, or different types of beds, etc. I appreciate it's not simple to just ask an ICB for more funding for these things, but it's something that needs to be thought about. Again, where possible, this is something that should be done at a governance level in advance, rather than on an ad hoc basis to think we need something else to be put in place and how can it be done. So there are all sorts of different stakeholders and relationships that are really important in these situations. And it can be very difficult to navigate if you've got a situation arising, particularly out of hours, and you've got a clinician or a small group of clinicians trying to find the best way to do things for their patient, without all of this information being very clear, having all the contact information for who they should escalate to, etc., etc. Hopefully this can all be planned in advance to support the clinicians and to make sure the patients get the right care. Another particular point is to think about the relationships with local authorities generally, and that's often a point of some friction in the cases that end up with us, where, for example, you've got approved mental health professionals, AMPs, who are very key to the decision making about whether the Mental Health Act can be used in a particular case. And there needs to be good relationships to make sure that those assessments happen when they should happen, that there is a good understanding and a cooperative, collaborative approach to the assessment, even if there's a disagreement about what to do. But you need to at least be able to get the AMPs when you need the AMPs. In wider sort of local authority terms, you might be dealing with children's services, you might be dealing with all sorts of statutory services that are around a complex patient. And in my experience, I would say that not everyone who works for a local authority will have a good understanding of the NHS systems. It will typically be based on what they have known in the cases they have dealt with, which doesn't teach them what is right, or it doesn't teach them who to speak to, or what is their role compared to the role of a clinician, in the sort of nuance that we would need. So we often get issues where we have, for example, a young person or a child who has got on a train and ended up in the wrong area, where they then present for care or are identified as needing care, and then which local authority should be involved can become a real stumbling block in trying to get decisions made correctly for someone. There might be issues around how safeguarding issues are identified and investigated, and whether that causes delays or hopefully can help if it's being done right. And it may not be that the Mental Health Act is the solution, but in these situations, if you've got discussions with a local authority, that might be helpful in working out, for example, who has parental responsibility, what are the roles of the different people around a patient, and particularly if you've got a child where the local authority has parental responsibility, they obviously need to be very important in all of the decision making. So there is a lot of complexity to this in how we might talk about the law in nice, clear, black and white terms, and then how it works in practice can be really hard to even get all of the right information from all of these people, and that can then contribute to staff making decisions not perhaps the way they would if they had lots of clarity and confidence and knew the situation they were dealing with, and relationships between organisations can particularly fray where people are in areas where they don't feel confident of the approach that they are taking.
So I'm going to talk now briefly about CQC and registration, but I'm going to deal with, we've got some questions which are already around the detail that we've sort of been covering. So I'll try and address some of these briefly. We can come back to them at the end if needs be. In a situation where patient Section 2 is about to expire and the team doesn't believe they will need to apply for Section 3, is it appropriate to wait for the Section 2 to expire, then discharge the patient, or should that patient be made informal? Strictly speaking, you should be making people, you should be discharging people from detention under the Act as soon as it's no longer necessary to have the Act in place. In practice, a lot of the time, in my experience, Section 2 just ends up expiring. But strictly speaking, they should be discharged, but that's a decision for the responsible clinician who would then discharge that patient.
I'd also say that Section 2 and Section 3 criteria are slightly different, and it may be that even though Section 3 isn't going to be required or isn't going to be appropriate, or you don't think that the criteria are met for Section 3 or will be at the end of the 2 period, but that doesn't necessarily mean that the 2 criteria aren't met at that point in time. So you don't have to immediately automatically discharge because you're not planning to use Section 3. But if it's not required anymore, then it should be discharged.
Do we have experience of a patient detained under the Mental Health Act having the section removed to an end of life so that you can complete forms without referral to the coroner? Yes, do have experience of that. But what I would say is the justification for doing that should not be it avoids referral to the coroner. The justification might be that if they're end of life, then maybe you're no longer treating for the mental disorder, or it's no longer necessary for them to be detained under the Act in order to provide treatment because they're no longer objecting to it or resisting it. I would also say that you should think about what is going to be your your legal framework for delivering any care that you want to deliver if the Mental Health Act isn't there. But in essence, if you're switching to end of life care, the argument would be that's not really care which is for treatment for the mental disorder. So it may not be necessary for the Mental Health Act to be implemented anymore. But that would be the justification for discharge, not because we don't want the coroner to get involved. Turning to this actual slide, then, a little bit of history, I think. It's the Mental Health Act 1983. For those of you who may go back far enough, you'll be aware that trusts came into existence in the 1990s. And that was also the point at which mental health services were separated from mental health services. And before that, it was there wasn't that degree of separation. There was obviously different qualifications and so on, but hospitals were run by health authorities, and hospitals provided physical healthcare and mental health care. Not necessarily in the same hospital on the same site, but there was a lot more mix. There was a much greater mix of professionals, and no specific separation between the organisations and their focus on delivery. So the Mental Health Act refers to a hospital, and that means any health service hospital. You cannot take yourself out of the Mental Health Act by saying, well, we're an acute hospital, not a mental health hospital. The reference is to hospital. And I very firmly believe that all hospitals should be registered with the CQC for the provision of mental health services. I am aware that some acute trusts have decided not to register. My original understanding, I have to say, was that the CQC didn't like that and was saying everybody had to register, but every now and again I still come across acute trusts that say, oh no, we haven't registered. I think that actually creates more problems than it solves, because I think you are putting yourself in a position where, in theory, you're not covered to use an area of the law, a legal framework, which can actually assist you in delivering care. I don't think it means that you can turn patients away who need your hospitals or your trust's services just because their condition is linked to a mental disorder. So if you're not registered, that shouldn't be preventing delivery of care and treatment to a patient who needs it when they need it. But you're putting yourself in the difficult position of saying, well, are we in fact registered and covered to deliver care under this regime? And if you're not, then you're either going to have to make some quick arrangements with the CQC, or you might need court permission to hold somebody in an unregulated setting, and you're looking at more expense, more complication, and more confusion. So I very strongly think that all acute trusts should be registered with the CQC for delivery of treatment under the Mental Health Act. In any event, the CQC is going to scrutinise paperwork, including any informal patients who might be authorised under a deprivation of liberty. And it's also going to scrutinise the use of restraint or ligature risk points in a building or medication management. So anything you do has this dual purpose that the CQC are going to look at anyway. So I don't think that not registering for mental health service delivery is actually helpful. I don't know if anybody isn't registered, but that would be my view. So there you go, that's it. It's fairly straightforward, fairly blunt about it, I'm afraid.
As we said, this is really about what you can do to plan ahead, and think about getting arrangements in place that are actually accessible and practical and helpful to staff and patients in order to provide the right care at the right time and to make sure everyone is clear on what they're supposed to be doing, what's expected of them, what their role is. So this should all be thought about at the right level and at the right time and in advance and reviewed periodically. And if not, there could be significant problems for trusts. Obviously, there can be significant relationship problems between trusts, or between a trust and other services that they're involved with, which are only going to hinder the lives of staff and patients if there isn't the requisite working relationship between them. But there are also risks in terms of, for example, claims being brought because someone has been in fact detained, but paperwork hasn't been completed. And part of the purpose of the Mental Health Act, which the next session will talk more about the kind of nuts and bolts and what each section is, but part of the purpose is so that there are safeguards in place for that patient and they aren't just being locked up by a doctor because that's what the doctor thinks. So if in reality someone is not being allowed to leave, for example, they need to have safeguards. There needs to be a framework around that, and the Mental Health Act might be the relevant one. It could be that a patient pursues a claim because the care that they've been given they didn't properly consent to. It was done on the basis that someone thought that the Mental Health Act might be relevant, for example. So there could be legal ramifications in that context. There are the numerous inquests that we deal with, where, for example, you've got someone wasn't stopped from leaving. There was plenty of information available about the risks that they presented and that it was so high that they should have been stopped from leaving. And in that sort of situation, it may just be information not being shared the way it should be. It might be a practical thing rather than a legal one. But if it's that staff don't feel comfortable dealing with Mental Health Act issues, or feel that if someone has a mental health problem or they're under the Mental Health Act, then it's for someone else to deal with, and that therefore a patient is allowed to leave or someone comes to harm in another way, because staff don't understand what they can and can't do clearly enough. Obviously, all of these things can also have significant reputational ramifications. And it can be that if someone has a bad experience that they make very public about having been held against their will, having been treated against their will, or having not been when they should have been, if there are cases like some of those inquests we deal with that become big stories for the press, then it can be that there's significant reputational harm, which again, it makes it further and makes the relationships more difficult, makes it harder for staff to do the right thing. And it might mean that patients are less likely to come forward and seek help when it's a slightly less complex issue before we get further into crisis, for example. So there are lots of ways that it's really important that all of this stuff is planned in advance, and the people at the right level are taking responsibility for sorting it out and making sure their staff know what to do. And a word on SLAs. Obviously, these are agreements between trusts or between trusts and other sorts of organisations, which hopefully give you the clarity about who is doing what. So they need to be in place. They need to be reviewed frequently to make sure that they remain practical to what the issues are that the trust and the clinicians are dealing with on a day-to-day basis. And they need to be able to accommodate all of these sorts of issues. So who is expected to do what? Where are the levels of support? Where are the lines of management and help? And what's the consultation between different organisations? Staff is obviously a big issue. Do you have enough of the right type of staff member available? Do you know how to get more staff when that is needed? Or who can fulfil what role? So who can be asked to take on restraint, for example? And where there's going to be joint working, who takes responsibility for what. Information sharing is obviously a huge sticking point at times. I think there's a lot better work going on now at different organisations sharing information more effectively while following relevant data rules. But those things need to be in place, and otherwise can create artificial barriers. For example, where a liaison service is provided by a mental health trust and doesn't have access to the notes of the acute trust, or doesn't have access to their own at the same time, then obviously information might be missed. It might be that you're dealing with complaints and disciplinary issues and problems that one staff member experiences with someone in another organisation, and you need to have a system and to know how to deal with that. Liabilities and funding are obviously sensitive issues that need to be dealt with in advance, and again at the right level and in black and white, so that the people on the ground know what to do. And all of this information needs to be accessible to them, which I wouldn't ordinarily expect it to be. SLAs are themselves published on trust websites or anything like that, or intranets, but the relevant information for clinicians should be then available to them in a nice accessible format, so that when the issue arises, they can find who they're supposed to ask for help and how to contact that person, for example. And we've had a question about the SLAs. They don't need to be in any specific format. They are contracts which need to be agreed appropriately between organisations. But there isn't any, for those that sort of touch on the Mental Health Act, that doesn't have any particular relevance, although obviously they need to have the relevant accommodations. It needs to be used the right language if it's going to include Mental Health Act issues. The SLAs that are most relevant to the Mental Health Act will be where it is Mental Health Act office staff providing support to acute trusts, and there will need to be specific delegation of acute trust as a hospital delegating relevant authority to the individuals, to the staff members, or the type of staff member that would be doing that, even if they're not directly employing them. And it's similar for associate hospital managers. That needs to be clearly in an SLA that is drafted to accommodate its involvement with the Mental Health Act, but it isn't a specific format that needs to be used. And all of this obviously needs to go in the context of staff actually working well together, understanding everyone's roles and being able to openly ask questions and things, rather than perhaps sort of a bit of distrust coming in, or a bit of perception that the mental health liaison service aren't doing XYZ that we expect them to, or the mental health liaison service saying we expect that the ED staff do XY, but they don't. There should be clarity about roles, and there should be opportunities to ask those questions, so that expectations are managed and marry up with whatever the agreements are for who's going to provide what.
Hey, if I could just bring in a couple of things I noted. I've been noting as we've been going through, perhaps to raise. I said I'd raise some stuff when SLAs came up. I think two issues that crop up time and again, I hope Clemmy would agree, but she may have others as well. Firstly, psychiatric liaison and any agreement you've got in place for psychiatric liaison. Being clear about what that actually covers. And one of the things in particular that can be very frustrating in acute trust clinicians is that the psychiatric liaison team will be saying things like, oh, well, we don't assess people for their mental disorder until they're clinically fit or they're clinically stable. And what the acute people may be looking for is, give me some help here on managing this person who appears to be presenting in a difficult way, whether it's a mental disorder or not a mental disorder. Their presentation that's driving it. Their presentation is something that you might be more familiar with than we are. How do we manage them? There's that aspect. There's also often an element of, can you help us out with deciding whether this person has capacity or not, and whether the way they are behaving, the way they are talking, the way they are presenting might be attributable to a mental disorder, or do we think we're looking for something else? So there's that earlier stage of working together before you're actually saying, are we going to detain this person under the Mental Health Act? That you may want to ensure that is covered. The other big issue, I mean, that's a lot of issues all sort of wrapped up in a very short comment. But the other thing I think we're finding at the moment that crops up and causes an awful lot of problems is the lack of mental health beds. And in particular, in relation to children. But if I start more broadly, a situation that Clemmy has mentioned, people presenting in your ED, I've had a specific inquest about this, young man, adult, but young man, presenting in ED, absolutely convinced that his problems, he was psychotic, but that his problems were cured by physical issues within his brain, that something had come loose and needed to be reconnected. He wanted a scan, he wanted people to identify what had come loose and be reconnected, etc., etc. He was clearly presenting as psychotic, got assessed by the mental health team, decided he needed to be admitted to hospital, no beds. Okay. Family saying he doesn't think it's mental health. If you actually tell him it's mental health and you're thinking of admitting him to a mental health hospital, then he'll be out of here. He'll respond badly and he'll be going. So that was sort of kept from him. He was reasonably happy to stay with his family while he thought he might be getting looked at acutely. But the lack of bed then extended to 16 hours before he got fed up and just walked off after he went off for a cigarette. And when he walked off, he ended up putting himself in front of a train, probably very spontaneously, not particularly planned, just came across a gate he could get over and saw a train track. But how the issue that Clemmy flagged there is who was responsible for him? How were the mental health and the acute health services meant to be working together? The paperwork, apart the recommendations to detain him under the Mental Health Act had been made. The only thing that was needed was an actual bed for him for the paperwork to be completed. So whose responsibility was he? He was still in the ED department. How often should his care planning have been reviewed? How often should somebody have been checking in with his family that everything was still okay, and did they still want all the staff to stand back and not, get too involved. All of that stuff. A lot of it needs doing on an individual basis, but does your working together arrangements with the mental health trust include how that's to be done, or how it's to be escalated if there's issues? And again, other cases that we see, particularly pediatrics, young people, maybe with self-harmed, so they need physical health care, or they have an eating disorder, so they need feeding in an acute hospital, nasogastric feeding or peg feeding in an acute hospital for a period of time. That is resolved in terms of physical clinical care. But the underlying mental health condition isn't. They need admission to what we call a tier 4 bed. There are none. Right? Where do they go? And you end up with people sitting in sometimes ED, more frequently a paediatric department for long. I'm talking weeks or months. I have a current case where we have a young woman who has been in the paediatric department. She's coming up to 18, so she may get transferred to adult, but she's been there for months. And all that we're doing is holding her down and giving her some feed twice a day. She's not really, the environment is not conducive to actually coping or tackling her mental health care. Now, that can be extremely upsetting and distressing for staff, and it can be very, very disruptive to the rest of the service. Now, there isn't anything you can do to solve the problem of no beds, but appreciating the problem in the first place and having some awareness of the level of support that everybody is going to need, so that it's not just your problem and everyone else thinks it's not our problem, is really important. Sometimes it can be about who's going to deal with it if it needs to be escalated.
Yeah, and I think the point of the webinar generally is if people kind of know what the position is on what their roles are, even though there isn't a legal solution to a lack of bed, and we can try to come up with things to make it, as lawful and appropriate and just as it can be. But at the end of the day, the Mental Health Act status is not really the issue if there isn't a bed. But if the clinicians understand and feel that they have done their bit correctly and are doing what they can for the patient, then hopefully it becomes slightly less stressful for them in their direct experience. So that is our last substantive slide. So I think we can move into
slide,
questions.
And we'll look at.
Do you want to start with the last one about those cases and whether you've got any comment on
who's responsible? The reality is that everybody gets a bit of the blame. Who is actually responsible may depend on the particular circumstances of each individual case. So as Clemmy says, at the end of the day, if as an acute trust you have a patient who is physically in your ED department, you're going to have some ongoing responsibility. You may feel that some of that responsibility, if as in the case I described, where section papers have been completed but for naming the actual hospital, that the mental health trust should take a more engaged view. In fairness, in the case I've described, everybody did what they thought was for the best, given that the family was saying, don't crowd him, don't make him aware mental health is, we're thinking mental health rather than physical health, don't crowd him, etc., etc. But it was what was going on in the background that ended up being criticised: the lack of review, the lack of structure to checking that the situation was still acceptable as time went on, waiting for a bed. So yeah, I can't give you a definitive answer as to responsibility, but if you've physically got somebody in your hospital as an acute trust, you're going to have a level of responsibility.
Well, Article 2, no, there is individuals have a right to life under the European Convention on Human Rights, but that doesn't give you any powers to do anything to them in order to preserve their life. It's more of a procedural obligation on the state generally. It's not something you can deploy to do anything. And it would only be relevant in the sort of, well, it's not even Article 2 that's relevant, but, you know, if someone lunges at your colleague with a knife, you can rugby tackle them, and it will turn out afterwards that you're probably not guilty of assault. But that's a very sort of different scenario. It doesn't help you in the waiting for a bed situation. Unfortunately, there isn't an easy answer for what's the legal framework when you're waiting for a bed. Case by case, we will do our best to help you with an answer, but there isn't just a straightforward one, unfortunately.
Coming back to situation where an acute trust has placed a patient on a CTO extended Section 17 leave, have I encountered any problems with this? I can't think, I don't know if Clemmy has, that I can't think of a specific case where I've come across it. My gut reaction, if I say it's a gut reaction, with my mental health lawyer head on, is I would have, my first thought is that I would advise, in when that situation may be arising or may be envisaged, that the formal transfer of care to the local mental health trust is appropriate, so that the CTO originates, because the CTO originates, or the Section 17 leave will be instigated by the responsible clinician, who, as we've already discussed, is likely to be a mental health trust employee, not the acute trust employee. They're responsible for making those decisions and doing that paperwork. In the CTO in particular, that's a community treatment order, for anyone that's not aware, which is a way of, you can add conditions to a community treatment order that people are supposed to abide within the community, otherwise they can be recalled to hospital. But you can't use that to detain them in the community. That's going to be managed by staff that are working in the mental health trust. So again, it might depend on the particular circumstances and what the concerns are. But broadly, I would be thinking that a patient's care, before you were thinking about CTO or long-term Section 17 leave, that's when people are still detained under the Act but are allowed leave from hospital. I would be thinking you would be more concerned with their mental health state rather than their physical state, and therefore care would formally transfer to the mental health trust, and they would institute those processes.
I'm not aware of dealing with any situations where an acute trust has put someone on a CTO. It does seem like they're probably not the best place to do that in most situations. And obviously the CTO has to be administered, it has to go through the responsible clinician. So it would only be if this is an acute trust that has an approved clinician who is the responsible clinician for that patient. There are lots of conditions around that. And you would obviously need making sure the paperwork really is right, particularly because CTOs can cause legal complications if the CTO isn't right and then that person is recalled and there's another period of detention under Section 3, for example. That wouldn't be lawful if the CTO hadn't been done right. But I see a follow-up question about use of Section 5.2 when someone else is a CTO, and there isn't really an answer to that, because obviously you could have a patient who gets on a train to the other, drives, I suppose is possible, to the other end of the country and presents somewhere with an acute health issue. You don't know they've got a mental health issue or involvement with mental health services, or you don't know who they are. And yeah, you could end up trying to use 5.2. I think as long as appropriate inquiries and steps are being taken. So if you know that someone has a mental health problem and they're from an area that you can contact, you can try and get information before the situation arises that a 5.2 might be needed. But at the end of the day, 5.2 is kind of an emergency situation and needs must. We have to do something now to keep this person safe. And if it is done with the best of intentions and in good faith, then it may be that you've got a sort of technical breach and someone has been technically unlawfully detained, but actually what should have happened is that they've been recalled from their CTO. And so it shouldn't be I wouldn't have thought that would be a significant financial claim. And you just have to do your best to deal with it. And obviously CTO recall is actually quite difficult because it has to be the responsible clinician. So if they're on holiday, eek. But in reality, as long as you're doing it with the best of intentions and with all the information you can have, I don't think that would be the biggest problem.
I want to just come back. There's two near the we came in early on that came back with. One, I mentioned specifically the Use of Force Act for patients detained under mental health. I confess I have not really looked at. I don't know which legislation you're talking about. It was the one that was coming in to allow better standards for use of restraint and so on in mental health units. I haven't had cause to look at it in great detail, I have to say. I can't remember what the definition of a mental health unit is. It might in fact cover an acute hospital if it's deriving it just as a hospital. If it doesn't, it would still be a good idea if you are going to be applying restraint within an acute hospital to make sure you're going to have to make sure that any staff that doing that are properly trained, that there are processes and systems in place. So it may be any guidance on that act is a useful starting point. I think that's
it might be helpful in terms of giving staff guidance about the limits on use of force and the alternatives and trying not to use of force. But I suspect it's going to be, there is a risk that if you're not routinely using force, if it's not something that comes up very often and staff are already trying to minimize it, if you don't need to have a policy under that act, but you have one, it might create more of an impression that force can be used. This is available to us. But it obviously will depend on the type of unit you're talking about and the type of issues there. And if it is a problem that is increasing and you do need to use force, then having a policy under the Act is potentially going to be helpful for staff.
Question here about police asking local authorities to be involved in bringing patients in under Section 5 and 6 of the Mental Capacity Act rather than using Section 136. There was a case that was saying that when the police purport to use the Mental Capacity Act rather than 136, but the person appears to have a mental disorder, then they're wrong. They should be using 136. There are issues with the phrase in the Mental Health Act that would be used, taking and conveying people from one place to another. So actually physically moving people, if they don't want to go under the Mental Capacity Act, is more problematic than it is under the Mental Health Act. So basically, I know there are lots of issues about the police. They don't want to get involved with mental health. They've been very successful in limiting, as far as possible, their need to be involved with mental health issues, frankly. Not least in getting Section 136 amended, but the police should be using Section 136 if they think somebody needs treatment in hospital and assessing for possible mental disorder. They should be using 136.
Yeah, and there's a
basically
question
that's the short answer
about the police and mental capacity relationship, and I 136 is their power. No one else can apply a 136. And I would be wildly cautious in taking legal advice from the police about use of the Mental Capacity Act. I mean, what they say to the, ambulance services is you probably can't get involved in, but it's not for them to say that someone, well, anyone, I suppose, can assess capacity, and you don't have to be a psychiatrist to do that. But it's not really for them to be making any comments about how someone should be being treated, how they should be admitted, anything like that. Conveying to hospital is unlikely to be your issue if you are the acute trust. You deal with them when they get there. But it's probably going to be a stretch to be using the Mental Capacity Act if there is a significant level of restraint, for example, being used to convey them, and if there is a significant deprivation of liberty being created by that. But we are very much steering into MCA territory, and today is MHA. I have to do a 6 hours webinar if we need to do both on their interactions.
And just on a similar vein, with possibly what may feel like an incomplete and frustrating answer, situation where hospital security often monitor and prevent a patient from leaving, but no applications have been made. This doesn't feel comfortable. It shouldn't feel comfortable. It isn't comfortable. If you are going to prevent somebody from leaving, then you need to be clear about what your legal framework for doing it is. There are basically 3. One is the Mental Capacity Act, what you need to be putting in the deprivation of liberty authorization. So you'd need to do an urgent authorization with your standard authorization being made. The other is detention under the Mental Health Act. And the third, for use in emergencies, is the common law, if you feel there is a real and immediate risk of death. And there's quite a bit wrapped up in that. So you need to be clear about what you think the risk is. They need to be clear that it's real and immediate, and it should be for the shortest, absolutely the shortest possible time until you can put one of the other frameworks in place. So that should not be going on for an extended period, and you have to be concerned the person's either going to kill themselves or that they'll wander out in front of a car, or there's arguments that can be made, but it really should be a short-term, a very short-term.
My sort of, I hear questions about use of the common law a lot more than I would like to. I think a lot of clinicians think it you know, they've heard it might be a helpful thing and you can, you know, stop someone and it's the common law. The best way I can distill the idea that you should not be trying to rely on the common law is that if you've got time to plan to use it, it's not a common law situation. It is I need to rugby tackle someone to stop them leaving because I've suddenly discovered this level of risk and I have no other option. If you have time to think about it and plan or discuss with colleagues, then it's probably not a common law situation. And, you know, it may be that then physically stopping them leaving might be assault, for example. Or it might be that you know, if you lock them in a room, that is detaining them unlawfully. So if there is time to plan, then you need to think about other options and not just rely on that. The other sort of, if there's a grey scale of how detained someone might be, if you've got staff present at the door and therefore they are not trying to leave, therefore they are not asking to leave, if it can be relationship managed, that people can be kept calm, can be checked on frequently, can be, I don't know, given something to do, if you can keep someone there with their agreement, even if their agreement isn't entirely enthusiastic, that is better than having to stop them leaving physically if they are asking to. So I know it's not always going to be easy or an available option, but that is obviously the first thing to try before you're thinking, you might be thinking we're going to need a legal framework at some point, but make sure that is relied on where it is appropriate and possible to just encourage someone to stay there.
We've got one here. Numerous incidents, recommendations are made, presume recommendations on the Mental Health Act, but the application isn't made as the acute hospital won't admit, and the RC is backing this as they don't agree with being responsible for a person in the acute setting. Leaving ED staff trying to manage the person in the no man's land. This is where your SLAs need to come in. This is where your discussions with other organizations need to come in. How are we going to manage these people? What people, I mean, you can start the discussion, I think, if you don't have anything already in place or you think it's inadequate, then get the examples of where you've had problems and start the discussion with those examples. We can't be doing this all the time. How do we deal with it?
Yeah, I think that's an issue that's going to be much easier to resolve in the cold light of day. There have been these cases generally, rather than it being someone is there right now, are you going to take responsibility for this, or this bad thing has just happened, and you know it's going to feel like attribution of blame. If you can say there have been a few incidents, it's not been very clear, what should we do next time? Hopefully it's more likely to get resolution and get the clarity that you need.
Yeah, I mean, I do think and one last one on 136. Because just two things to tie in with 136. I mean, the patient that wants to leave ED, you can't use section 5.2 because they've not been admitted to hospital, but you can now use section 136. Whether you can get the police to come along and use it is another matter. But it is clear that you can use 136 in an ED. But someone here is saying next steps with regards to police arriving in A&E on a 136 and wanting to hand over to clinical staff. That's meant to be dealt with in local agreements between the police and health. The police do not want to stay there, and health but especially in acute trust, you will often feel you don't have the training and the staff and the ability to manage people who may be, it's quite likely they could be behaving in a fairly disruptive manner, because that's why they've drawn the attention of the police in the first place. The police have pushed back a lot on the idea that they should remain there until a Mental Health Act assessment is completed. But I'm afraid the best I can say is that's something that needs to be resolved at a local level. It may vary from case to case, and one approach to an answer might be an agreement that there can be quick contact between senior level people within each organisation. So it's not a matter of the staff in ED trying to persuade the two police constables that turn up, or the one police constable that turns up, to stay when they've been told by their sergeant there's something else for them to do. It's your duty manager speaking to the inspector and getting them authorised to stop longer because of the way that individual happens to be behaving. A lot of these things come down to nobody's got the time, nobody's got the resources, and nobody's got the staff anymore. And there isn't anything you can do to solve that. You can just try to keep lines of communication open.
There'll be more in the next session about specific sections, in the next webinar on specific sections. But briefly on that question, so the police can hand over someone who is on 136. The 136 doesn't end because of that. So the 24 hours that begins on their arrival will continue, and it will expire when it expires, unless it is discharged sooner. But the 136 power is only to take and convey. So it can hold someone there for that period of time, but it doesn't give you any powers in terms of treatment or anything. And it is just for you to do the Mental Health Act assessment and make any necessary arrangements for care thereafter. So it is quite limited. It is just, you can stop that person leaving. And then the perennial question, which, and we are going to have to stop soon, but yeah, you've got your Medrex, there's no mental health bed available. How long can you keep them? Yeah.
There's no, well, you haven't actually got any league. The completion of the medical recommendations doesn't trigger a power to detain the individual.
Yeah.
Is a short
the completion
answer.
of the application does. So if you know where the bed is going to be, or what have you, if the paperwork can be completed and if the AMP is willing to do that, and you have a complete application, but the bed isn't going to be available for 6 hours, then section 6 will allow you to transfer the patient when the bed becomes available. But it's not what that section is intended for. It's intended for if you've done an assessment on someone in the community and then you use it to bring them into hospital. And yeah, that is essentially, you're in the same situation as when a 136 expires. There is no straightforward legal answer that we can give you.
Yeah.
I'm sorry.
I'm not sure how much any of these things are going to be solved by the new Mental Health Act. Lemmy and I were discussing this, just a final comment, discussing this before we started here. I doubt the new Mental Health Act is going to come in before the election. So I don't know whether it will come in at all, or in the form that it's in. And many of these management problems, I think, derive from two things. They derive, one, from the separation of acute care and mental health care, in terms of different trusts dealing with it, so that there was a gap created there, which we've spent the last 30 years again trying to bridge. But more fundamentally, it comes from lack of resources. The Act just wasn't designed for circumstances where there isn't a bed available.
Yeah. Just one more thought, if I can, before we wind up, is just to say, if you've got more questions, particularly anything specific about nuts and bolts of situations you're dealing with, rather than this kind of bigger scale management question, please do feel free to put that into your feedback forms or to email Heather or whatever, so that we can incorporate it into the next session. We will be talking through the different sections and what they are and how they work and what the requirements are. So we can add in extra comments if that's helpful, because what questions you have are probably questions other people have, particularly the devoted few who have stayed with us even though we've overrun. So do let us know if there's anything else that would be helpful to cover.
Thank you.